As jury selection begins in a landmark trial over alleged social media addiction today, TikTok reached a late-night agreement Monday to settle the case. The trial will now center around Google's YouTube and Meta, which owns Facebook and Instagram. Snapchat's parent company, Snap Inc., also settled the case last week for an undisclosed amount. The case was brought by a 19-year-old who claims that using social media from a young age led to a technology addiction. She says this caused her to develop depression and suicidal thoughts. It's the first in a series of lawsuits expected to be heard this year against popular social media platforms. Executives, including Meta CEO Mark Zuckerberg, are expected to testify at the trial, which will last 6 to 8 weeks. Let's bring in Stuart Benjamin, a professor at Duke Law School. Stuart, what will the lawyers for this 19-year-old have to prove to win their case?
So they have to prove that design features of these social media sites caused this plaintiff to suffer from anxiety, depression, etc. That is to say, things like infinite scroll and autoplay, and not the content that was actually on these social media sites. And the reason why it's important for them not to focus on the content is, if it's a focus on the content, then there's a federal statute called Section 230 that would prevent them from being held liable. And they would have a strong First Amendment argument because they would say, you're punishing us for our speech. That's not permissible under the First Amendment. Whereas the argument would be that things like infinite scroll aren't really speech, and it isn't someone else's speech, and so neither the First Amendment nor Section 230 applies.
And so what arguments could Meta and YouTube make against these? I mean, couldn't they essentially say, look, we're in the business of keeping attention, and this is how we do it?
Sure, right? CBS News is in the business of keeping people's attention, right? Every website is, and part of the problem is, again, a lot of that is the speech, the First Amendment speech of these entities. And so they have made that argument, and they're going to make that argument, that these features are fundamentally part of their communication. The counter argument is going to be, no, you're not really communicating anything with autoplay and infinite scroll. All you're doing is just trying to hook people in. And so there's no real element here of a real meaningful communication that's going on.
Is this a bellwether?
Yes, absolutely. I mean, the stakes are high on both sides. So if the social media companies win these cases, it's going to be very hard then to have the government be able to have any control over these design features or any real influence over the design features. On the other hand, if the social media companies lose, then you can imagine lots of later cases challenging other design features. And, there are many, many design elements of these platforms, let's just put it that way. And you can easily imagine lawsuit after lawsuit challenging various elements of those design elements.
Stuart Benjamin, likely won't be the last time we call you. Thank you so much.
Happy to be here.